that they would put down. You have that right, and they can't pass a law that takes away that right. Secondly, if they do, it's unconstitutional. Thirdly, no state may convert a secured liberty into a privilege and issue a license and a fee for it. And if they do, you can ignore the license and the fee and engage in the right with impunity. Shuttlesworth v. Birmingham, Alabama. And since you have not willfully done anything evil, you have relied on your Constitution and on the Supreme Court decisions, you have a perfect defense to the charge of willfulness. So you could not have been charged with willfully not going and getting the license. Does everybody see that? Okay? You have a perfect defense. United States v. Bishop, 412 U.S. 346. Defines willfulness as an evil motive or intent to avoid a known duty or task under the law with a moral certainty. Obviously, you didn't do that, did you? Because you have a perfect defense. You relied on previous decisions of the Supreme Court, Shuttlesworth and Murdoch and Marbury. You relied on your constitutional right to travel freely unencumbered, pursuant to Shapiro v. Thompson. So you have a perfect defense. So now where are we at? Your Honor, may it please the Court, I motion for dismissal with prejudice, failure to state a cause of action for which relief can be granted, and I would like to motion to dismiss, and I'd like my costs and fees for having to defend this frivolous case. That you have a right to collect your time for going to court, all right? You submit your bill, you submit your proposed order, you fill out your own proposed order. That makes the case go faster, and the judges kind of like that, and it intimidates the hell out of the prosecutor when you do your own order. Now, let's say, well, that's how you interpret that, sir. That's right, sir. That is how I interpret it. And 16th Am Jurisprudence, 2nd, Section 97 says that it shall be interpreted in my favor because I am the clearly intended and expressly designated beneficiary of the citizens for the protection of rights and property. See Briars v. United States, 273 U.S. 28. Unlawful, and that deals with an unlawful search and seizure, but it also deals that it's supposed to be interpreted in favor of you, the clearly intended and expressly designated beneficiary for the protection of your rights and property. So they got to enforce it in favor of you, right? Now, Boyd v. United States comes next. The court is to protect against any encroachment of constitutionally secured liberty. It's their duty. They have no choice. They have to do it. Okay? All right? In Norton v. Shelby County, an unconstitutional act is not law. It confers no rights. It imposes no duties. Affords no protections. It creates no office. It is in legal contemplation as inoperative though it had never been passed. Now, after you write all of this stuff down, you casually say, "Wherefore, Your Honor, I pray before this honorable court for your just and lawful relief. I ask that you dismiss this case with prejudice for failure to state a cause of action for which relief can be granted, and I pray the court for my just relief for having to defend this patently frivolous and spurious case, and my costs are whatever they are." You submit that on your order. I have an order. I have a proposed order, Your Honor. It's in my brief. At that point, they will turn to the prosecutor and say, "Well, Mr. Prosecutor, what do you think you'd like to do about this?" And most of the time, they're so overwhelmed at this point that they just go, "I'll go for the dismissal, Your Honor." And the judge will give them some slack. "Well, never before was a young man, not attorney, so literally overwhelmed when it counts for the prosecution, a licensed attorney." Now, it's not my goal to make attorneys look bad. My goal is to make you look good. My goal is to make you understand your Constitution. Now, if you happen to do it and you do it better than the attorney, God bless you. And God bless America. And if the attorney doesn't do his homework and prepare his case, I have no sympathy for him. Because he shouldn't have done what he was doing anyway. And if he'd had any brains, he'd have pulled you aside and he'd have done what other attorneys have done to me and said, "You know, I hate going against the pro se litigant attorney." Almost always they're really, really good. And you know, I never get to find out if they're really, really good or they're really, really bad until I show up, and then it's too late. So I'm already on the diving board. And either the pool has water in it or it doesn't. And usually it doesn't. And it hurts when you hit the bottom. So they don't like going against you people. They will not like going against you. If you halfway know what the hell you're talking about, they're going to be intimidated. And I can tell you many, many, many tales. I had this one gentleman, he didn't have any plates on his car, and they called him into the court. And he was standing in the hallway, and the prosecution said, "Would you come over here, sir? I'd like to talk to you." He came in the office, and he sat down. And this party said to the prosecutor, "What can I do for you?" The prosecutor said, "Sir?" He said, "What can I do for you?" He said, "Well, it's not what you can do for me. I'm the prosecutor. What do you want to do in this case?" "Well, I assumed there was something I could do for you. You called me in here." "Well, what do you want to do? How do you want to plead on your case?" Oh, I don't intend to plead, sir. I intend to answer in the form of a demurrer, such that I do not acquiesce to quasi-jurisdiction, because that's an issue to be brought up in my pleadings and briefs to file with the court. The guy's mouth was on the ground. He said, "Are you an attorney, sir?" He says, "No, I'm a truck driver." The guy absolutely was in a panic. I had the same gentleman later, he was working as a bricklayer, and he did the same thing. Told the prosecutor he was a bricklayer, and the guy's jaw was on the ground. See, they don't anticipate that people that are in other jobs other than theirs have any brains. And it blows their doors off when all of a sudden this bricklayer or this truck driver can come in and argue law, and all of a sudden it's like, shoot, this guy is good. I have to treat him like he's an attorney. So what did this guy do? The first thing he does out of the chute, he walks up to the judge and he tells the judge, he says, "Judge, I'm going to dismiss this case." Because he realized he was going to get hammered. And my guy says, "He can't do that. I took day off work to come over here and battle." I told him, I said, "Shut up, sit down and relax. You won. Don't say nothing. You won." And the judge broke out laughing because this guy didn't want to quit. The judge turned to him and he said, "Well, evidently the prosecutor doesn't want to proceed, sir. I'm going to have to dismiss the case. He is the complainant." "Can he do that, Judge? He can't do that. I'm here to battle. I want to go. Let's do it." And the judge laughed again. He says, "Well, apparently, sir, I cannot sustain a complaint that is not properly before the court. Counsel for prosecution has entered a motion to dismiss, and I have no other option but to dismiss. Now, if you want to countersue him, that's another case." "Well, I'll do that. I'll do that." In the meantime, I told him, "Will you be quiet and submit your bill? Submit your bill. You won. Submit your bill for your damages." So he did. He said, "Well, I'll submit my bill then, Your Honor, for my costs and fees for having to defend this frivolous case." And the judge smiled, because people don't usually do that. But if you win, they are required to pay you. That's the rules. If you lose, you pay. So the bottom line is this. When you file your papers and they turn around and you get a win, make sure you got your little bill in there for your lost time from work, or any copies that you had to make, or any visits to the law library, or any what is called real and personal damages. And don't pad the account. Put down exactly what you got, because if they force you to prove it, you can get busted for perjury. So I don't recommend you shall we say, stretch the pad. I recommend you put down exactly what your costs are. Believe me, the fact that they got beats plenty enough of a sting, and the fact they got to pay a couple $100 for your lost day at work will be more of a sting. And you will get a code on your license, and the next time you get pulled over, they will just hand your license back and tell you to think about slowing down and have a nice day. Because they don't like people like you. Because you're an American. And Americans don't give up. And they never surrender, and they fight. One judge told me one time, he said, "You got any kind of idea how much money you've cost this court today?" And I said, "I hope it was a bunch, Your Honor, because I hope you got to go write a whole bunch more tickets to break even." The way I figure, the more tickets you got to write, the sooner the public's going to wake up to this theft, and maybe they'll start doing something positive to stop this kind of stuff, because it's my belief they should be having masks on out there, because, I mean, if they was an honest crook, they'd be having a mask on there when they robbed the people. Okay? Well, he didn't like that answer too good, but the bottom line is he knew I was right, and after a while they realize what your goals are, and they know, hey, this is more fun than Edgewater Park, and I want to go on all the rides twice. You know what I mean? I want to hit the Wild Mouse and a whole bunch of them other rides. Let's do it. And see, when they see that, they realize there's no point. You're not going to learn anything. You're going to cost some time, money, materials. Now the system is not profitable. Okay? So they back off. They put a code on your license. They won't bother you anymore. Now, did everybody see we take that line down? We take the line from the Constitution. We take the line from the right. Now let's think up another right. How about the right to work? Contract your labor and your skill and your time of life as you see fit. Now, your right to work is protected by the Constitution under the First Amendment. Again, you have a right to work and contract your labor and your skill and your time of life as you see fit. I get hauled into court before the chief judge of this big court here in Oakland County. I won't give you the judge's name because he was a fair judge and a good judge, and I'm going to let him slide. But the bottom line is this. He looked just like Abe Lincoln. I mean, exactly. He was the spitting image. And he leans over the chair and he says, "Well," he says, "it's been reported to me, son, that you don't have a license to practice law. Is that correct?" And I looked up at him and I said, "Judge, I'm not practicing. I know what the hell I'm doing." And the whole court broke out laughing. He said, "That's pretty good. That's pretty good. I like somebody with a sense of humor." He said, "But that doesn't change anything, son. you have to have a license to practice law. And I said, Your Honor, I'm an unenfranchised common law free man. I live at the common law. I am not a participant